Hear ye. Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment. God save the Constitution and his honorable court.
Good morning. The case before us right now is UE Logistics versus Patsfield. Will the parties make their announcements?
Good afternoon, Your Honors. I am William L. Van Fleet. I'm here today representing the appellant and cross-appellee UV Logistics.
Okay.
Hi, Your Honors. My name is Susan Clothier, and I represent James Mark Patsfield III, who's the appellee and cross-appellant.
Okay, let's begin. Let me start with a question. I know, Mr. Van Fleet, you're going to want to talk about whether there's a cause of action for fraudulent inducement to continue performing a contract. But I would like for you to please address for us the language in the emails and whether or not that's evidence of a then present intent to break a promise. Is that understandable, my question?
I think so, Your Honor. This case centers around an email sent on April 14th, 2014 by Tim Daly, who was a vice president of UV Logistics. It was an email, actually part of a series of emails sent by Mr. Daly to Mr. Patsfield, telling him that, among other things, he was no longer to communicate with the then regional supervisor, a fellow by the name of Burkett, but instead to communicate with Mr. Daly directly, along with another vice president in the headquarters of UV Logistics. And it further stated, and this was what Mr. Patsfield at trial centered his claim around, upon language in the that April 14th email, which said, "We can make this work. Let's make this right." That email was sent 3 days after Mr. Daly.
We read the emails, Mr. Van Fleet. I guess we want to get to sort of the legal issues here.
Sure.
So in particular, did UV Logistics breach the contract with Patsfield?
It did not. And the evidence showed that. First of all, as the court knows, the trial court previously dismissed Mr. Patsfield's breach of contract claim on summary judgment for several reasons. Although the court's judgment does not specify the precise reasons for dismissing it, the reasons were as outlined in the motion for summary judgment and as supplemented by the trial record. If you want to go into the reasons why UBL did not breach the agreement, was that after the April 14th, 2014 email was sent by Mr. Daly, UVL continued to perform all of its obligations under the underlying contract, what we call the ITOA, for over a year. It then found out that Mr. Patsfield had signed a contract with one of UVL's competitors.
Well, I guess so, but then UV Logistics stopped performing the contract. But it's your position that it was a justifiable breach, justified by Patsfield's breach.
That is correct, Your Honor. In fact, the ITOA itself specifically gave a either party who was not in breach of the contract the right to immediately terminate the contract if the other party did breach it.
So UV terminated the contract after what happened, it contended, was that Patsfield had breached the contract.
Right, by signing up with a competitor in violation of the express terms of the contract.
So was New Lumber actually a competitor at the time that the contract was terminated?
Yes, and in fact, it had signed up Mr. Patchfield, as the testimony at trial showed, for the purpose of expanding its presence in the Pennsylvania shale play.
I thought that they were transporters of lumber, not energy equipment.
No, they transported everything. And they were trying to grow their presence, according to the testimony at trial, in the Northeast, specifically the Pennsylvania shale play, where lumber doesn't even factor into it. They were trying to haul, get a bigger toehold into hauling oil field equipment, which is where all the money was.
Okay.
So that leads, I'm sorry, I thought one of you was speaking. That, of course, leads into the whole point about how can Patchfield claim that Daly did not intend for UVL to continue to abide by the terms of the ITOA when the evidence undisputedly showed that UVL did comply with the terms of the contract for over another year until Mr. Patchfield himself breached the ITOA and was terminated for that breach. When the evidence conclusively proves the opposite of a vital fact, in this case, the intent of UVL to abide by the terms of the contract so long as Mr. Patchfield did, then that evidence is the evidence supporting the jury verdict that held to the contrary is by definition legally insufficient.
Can we discuss the
Sure.
The motions for summary judgment filed by UV Logistics?
Yes,
Were they hybrid motions, or were they traditional or no evidence?
it was a hybrid motion. There was an original motion which was superseded by an amended motion, which UV filed, and it expressly stated in the amended motion that it was bringing the motion for summary judgment on both traditional and no evidence grounds.
And it's my understanding that Patchfield subsequently specially accepted to the motion for summary judgment on grounds of specificity.
He specially accepted to the original motion and also asked for a continuance of that motion, which was granted, which led to the filing of the amended motion.
It was the amended motion specially accepted to.
It was, Your Honor, but Patchfield never sought or obtained a ruling on those special exceptions.
Was there a ruling on the first round of special exceptions?
No.
Just simply the continuance.
Yes, sir.
Okay.
To continue on, there was simply no evidence presented by Mr. Patchfield that Tim Daly did not intend for UVL to continue to perform its obligations under the ITOA. And it did, in fact, do so for over a year. On top of that, we get to the damages issue, and the fatal flaw throughout all the testimony and evidence is that nobody ever offered evidence of what damages, if any, did Patchfield suffer as a result of quote unquote remaining in the contract.
Is this a causation challenge, or is this a challenge to the amount of damages?
It's both. First of all, it's a causation challenge because the only evidence about how much money Patsfield made by remaining in the contract was that he made more money than he ever had in his life. He grossed over $7 million. Problem is, nobody ever testified or presented evidence of what expenses he had. He sued for net profits. You can't figure out net profits if you don't know what the expenses are.
Did the expert testimony regarding damages on ongoing loss of income quantify or in any way account for things like the variability in the oil market, which has a huge effect on the profitability of oil transport companies?
The damages expert did say cursorily that he took that into account, but didn't explain how he did so.
Okay, let's hear Ms. Cloutier, if I've pronounced that right. Ms. Cloutier, can you hear me?
I think I got it. I'm sorry about that.
Okay. How do you respond to Mr. Van Fleet's comment that they did not breach any contract or breach the cause of action of fraudulent inducement to continue performing because they performed for over a year afterwards? And that the breach occurred by Patsfield and not by UV Logistics. What's your response?
There's a provision in the contract, to my understanding, that Patsfield was permitted to engage in business with, they were not limited to just engaging in business with UVL. And also, the breach is not necessarily going to be related to whether it's a claim, a cause of action. It's more the breach of contract claim was dismissed in the motion for summary judgment. The motion did not specify in that motion whether, it did say that UVL did breach or that it supposedly breached by not giving a 30-day notice. I'm not sure if I fully answered your question.
Okay, I think we're trying to communicate. The sound is a little odd. I hope you're understanding my question, which was, the Van Fleet is saying that they can't have fraudulently induced Patsfield to continue performing contract because they performed the contract over a year longer than the original email that says we continue to move forward with support.
Okay, I'm sorry, I didn't understand the question on the first go around. The relevant inquiry is actually at the time that the promise is made. That's what case law states. Whether or not the party continues to perform can be taken into account when the jury is deciding whether or not there was a fraudulent misrepresentation. But that's not the primary concern. It's what their intent was at the time they made the promise. In this case, the intent was established through those various emails that made it, could easily, as a reasonable jury, could conclude from those emails that they intended to not fulfill the promise they had made to Patsfield to continue the contract in an effort to poach his drivers.
Did they say they were going to continue support? I mean, the purportedly fraudulent representation is we will continue to move forward with support. Is that what you're relying on here?
Yes. So that would be what they were telling.
Does he say continue to move forward forever? Does he say a year and a half, 2 years? Or does he just say we'll continue to move forward? And if so, why isn't continuing to move forward for 6 months? Make that a non-fraudulent statement.
Or over a year.
I understand the question. I think that if this were a different inquiry and we weren't looking at a jury finding, then you could weigh those statements and all of those facts, but the jury's in the best position to determine credibility of witness statements and facts and determining the outcome. In this case, they clearly had, determined that at the time of the email, which occurred 3 days before the email that they sent to Patsfield stating that they wanted to continue the contract, that email could be inferred easily that they did not actually have that intent. And so what they then subsequently did was the jury interpreted as keeping him strung along long enough to get all of his contracts, because the jury's decision to determine the credibility that email meant what Patsfield contended that it did. So I don't believe that it's as important. I think the jury could have taken into consideration the actions that occurred between that email and when the contract was terminated in 2015. But when they weighed that evidence, they determined that the other email was far more evident that they did not have intent at that time.
Were there any objections to the fraud question that was posed to the jury?
I'm sorry, could you repeat that question?
Did either party object to the fraud question that was posed to the jury?
UVL attempted to object. They started to object, and the judge said, "You are just making a closing argument right now," and did not accept an objection or rule on it. So our contention is that that would be waived.
Has there been charge error alleged on appeal?
Charge error was alleged on appeal, but it was presented and framed as just that it didn't frame it as charge error. He framed it as that the tort was not a valid tort in Texas. But that argument itself is not preserved because of the fact that they did not object at the charge conference. The motion for directed verdict was prior to the charge conference. So anything that was raised in that would not be sufficient to preserve at the actual jury charge question. And then there was a motion for JNOV.
Let's assume that the charge question was proper, okay?
Okay.
And so the elements that were presented to the jury were UV Logistics made a false promise to do an act. What was the promise?
The false promise was saying, we want to continue, let's do this.
Okay, all right.
So
the promise you're relying on is in that email says we will continue to move forward with support. We can make this ride, that sort of puffery email, right? What is the act that was promised in that promise?
A continuation of the contract. That when you look at the terms of the contract, either party could terminate with 30-day notice at any time. It's not a typical contract where there's a term of 5 years or 10 years. It had a termination provision. So because of that, stating, they may have been communicating about him potentially terminating. They're trying to prevent that from happening. So a lot of the case law cited.
So if UV could have terminated with 30 days notice and still be within the bounds of the contract, did UV Logistics terminate within 30 days of that email?
No, they did not. But I believe that our issue is really whether or not them trying to prevent Patsfield from exercising his right to termination in order to poach his business. So the Patsfield could have terminated at any time. At that point in 2014, UVL was trying to prevent him from doing that. They wanted him to continue along. So they're saying, everything's fine. Let's just keep going. We're going to make this ride. But, completely, contemporaneously with that same email, internal emails are showing that they do not actually have that intent. At least that's what the jury inferred by those emails, because at the exact same time, Patsfield relied on the belief that they wanted him to continue the contract. So he did not exercise this 30-day termination right. And that's where the damages come in, because between then and when they did.
Let's turn back to this email, right? So we will continue to move forward with support. Does that say we will continue to perform the contract? We will continue to abide by the contract, or we will continue to give you shipments? Or what would the dictionary say is the meaning of move forward with support?
Well, certainly wouldn't mean we are planning to terminate the contract. And this inquiry is not whether or not we believe that that means what the jury believes that it means. It's whether or not no reasonable juror could have found that that meant that they wanted to continue the contract. I don't think that it's unreasonable to believe that it did, because it is clearly stating, stick with us, don't leave us, let's do this. It was a little bit of as to casual terms that were used, but I think it's pretty easy to infer from those terms that
So
intent was there.
And the next question is, did UV Logistics continue to move forward with support after this April 2014 email?
We don't know that. So the evidence shows that they did not terminate until 2015. But what they were doing in the meantime was trying to recruit his drivers that he brought to UV Logistics initially. So during that time, prevented him from then when he terminated, he did not get to bring his business with him where he would have if he had terminated at that time.
When during the year did that start to occur?
I'm sorry, what?
This recruiting process, you seem to be hanging your hat on.
Mm-hmm.
When did that start to occur?
I don't have the specific citation. I believe evidence at trial showed that it just occurred at some point during the period. The email, there was further emails that talk about that they want to go after all their trucks. That's at 5th reporter record at 133 was a email from Vice President Tim Daly. Again, Mark is drafting a letter he will be sending with the intention of separating Jimmy from going after all the trucks that are still leased to him. That was in May of 2015.
Right, so that's more than a year after. So my point is, we've been having a continuation. They've continued to move forward with support for at least a year. So why does that make this statement in the email that we will continue to move forward with support false? Why is that a false statement of intent? Because they did continue to move forward with support.
I think because there was a contemporaneous email indicating that they were not planning to do that. So their illusion of continuing with support was what occurred, not an actual continuation of support.
Tell me what the other part of the email is that you're referring to. Are you referring to the email that says drivers are unhappy with Pattsville and many would not follow Pattsville if he leaves or if you get rid of him? Is that what you are meaning?
That is, yes, Chief Justice, that is what I'm referring to.
If that's true, isn't that evidence of really two possible outcomes? One, that he leaves on his own will, or two, we get rid of him. So is that a little bit ambiguous, perhaps?
I believe that, the jury has to make those credibility determinations and determine what it meant. And that's what they did. Their verdict reflects that they believed the fact that that email was sent 3 days before the second email that we've been talking about reflects the fact that they believe that the intent at the time that that email was sent to Pattsfield, that they did not actually have the intent to continue performance, but rather had not planned on continuing the performance.
But you're just saying that it's the jury's decision, but the question is, how does that email advocate any intent to choose one outcome over the other?
Either one of those outcomes would result in termination.
That the main part of the sentence is drivers are unhappy, and talking about drivers that many would not follow him if he leaves. They're talking the main subject of the sentence is drivers. Do you see where my question is? They're unhappy, and we're just talking about the drivers being unhappy, not about logistics thoughts one way or the other about what they're going to be intending to do. They're just talking about the drivers being unhappy.
Mhm. I think that it can still, the law says even minute amount of circumstantial evidence the jury can infer intent. So it can, if we are looking at this in a de novo review, of course, we could say that doesn't seem to fit. But that's enough, just that there's an indication that they're not aligned with Patsfield when 3 days later they said they were. They don't match.
Okay, well,
If-
then last question, is there any other part of the email that you'd like for us to consider as helping to establish intent? Have we any of the other parts of emails?
I think the September 12th, 2014 email, which appeared on the record, 5th volume as well, 116, would also indicate that said that if he would have been working to build up the company's store instead of worrying about the commission agents are doing, we wouldn't have to be bowing down to the agents. That could easily be inferred as well, that they were not wanting to continue to do business with Patsfield because they want to cut out the middleman so they can make more money. But if they had terminated in 2014, Patsfield most likely would have been able to take his business back with him and leave. And in fact, he did not get to do that because of the actions of UBL.
Before we conclude, I had a couple questions. Do you agree with Mr. Van Fleet that you did not get a ruling on your special exception?
I'm going to contend that it doesn't matter. That there's First Court of Appeals case law that still reached the issue of whether or not the party received fair notice, even if it wasn't preserved. And therefore,
are you agreeing that you did not get a ruling, but that it doesn't matter?
I'm not agreeing or disagreeing. I don't have the answer in front of me, but I would say that even if we didn't, it still wouldn't prevent the court from evaluating whether fair notice occurred.
Okay, my second question is, how is the causation not negated by the jury's verdict on tortious interference?
Causation on damages?
Yes.
I'm sorry, could you ask that a different way? I'm not sure what you mean.
Well, the jury did not render a verdict in your favor on the tortious interference claim. So they don't think that UV Logistics' actions were to steal the drivers and interfere with those contracts. So how do you show causation for your claim that you did prevail on?
I'm sorry about that. I think, well, first of all, I would say that I think it's important to note that their arguments about causation and insufficiency of the evidence for damages are waived. They didn't brief them at all. They just made a statement.
Let's set that aside. I'm just asking, How do you connect the jury rejecting the one claim with your burden on the other?
I mean, because the profits, the net profits that could have been determined that he would have made as a result of not continuing in the contract would support a damages award. So you could have one and not the other. Because the fraud itself that the jury found was that they did not intend to follow through with their promise and induced him to continue and not terminate the contract, and not specifically related to fraudulent inducement to entering the contract, which is a completely different tort.
Okay,
where did the damages come from? I mean, where is the lost money? It's lost revenue, right?
It's not considered. I mean, they look at lost profits, so net profits,
right,
and not revenue. There was several people testified, including the expert, about what lost profits he received as a result.
Where does the money come? Where does the revenue come from?
He obtains revenue from drivers.
From drivers, okay.
And from his own, yes.
And so why wouldn't he be getting that revenue by continuing to perform the contract?
Do you mind if I submit a post-submission letter answering that specific damages question since we're out of time and I don't have the information right in front of me.
If it's okay with the Chief Justice, I don't have a problem with it, but I ask you to keep it under 2,000 words.
Not a problem.
Okay, thank you very much. We'll hear from Mr. Van Fleet now.
Thank you, Your Honors. If I may start, I'd like to circle back to a question Mr. Justice Kelly asked early on in his quizzing of Ms. Clothier. And I'm afraid she made a mistake. Mr. Justice Kelly, you asked whether or not UBL made any objections to the submission of questions number 5 and 6 dealing with the fraudulent inducement to remain in the contract. The answer is absolutely yes. UBL objected on the record to the submission of both questions on the basis of factual and legal insufficiency. I believe what Ms. Clothier was referring to in her response was that prior to that, UBL had moved for directed verdict on the basis that the cause of action did not exist. But during the charge conference, UBL also specifically objected on the grounds that there was no legally or factually sufficient evidence to support the submission of the question, either whether Mr. Patsfield was fraudulently induced into remaining in the contract or the damages, if any, that he may have suffered as a result of doing that. Second, I would like to then go to Ms. Justice Landau's very excellent question at the end about doesn't the jury's finding that UBL did not tortiously interfere with Patsfield's prospective relationships with drivers or customers negate any damages or any claim he would have. That is precisely the problem that we pointed out in our response brief that Patsfield has here. He keeps conflating his claim for fraudulent inducement to remain in the contract with his separate and distinct claim for tortiously interfering with his prospective business relationships with his drivers and or customers, which, as you pointed out, Justice Landau, the jury found against him on. So Patsfield cannot now double back and say, well, really my damages for remaining in the contract was giving you the ability, UBL, to poach my drivers. The jury didn't buy it, found against him on that point. So he can't double back now and say, those were my real damages for remaining in the contract, i.e. continuing to perform my obligations while
But the
UBL
jury did find some damages.
for the remaining in the contract question. Yes, $450,000. To be honest, Mr. Justice Kelly, I've tried a lot of cases in my life, and just like I think every other trial attorney, I tried to figure out how the jury got there on some questions. I still have been unable to figure out how the jury could have come up with the $450,000 that it did under any scenario. It appears to me, frankly, they just picked a number out of the air because there's no evidence that comes close to supporting $450,000 for the few months remaining under the contract before he was terminated.
To a wide range of damages amounts, and the jury is not bound to find one particular figure, but is it within the range of damages models that the expert testified to?
Actually not. It's beneath the range. He testified to between 1.5 million and 4.5 million as damages. Now, the expert didn't testify. He testified, you'll recall, as to what Mr. Patsfield's damages would be from the date he was terminated in May of 2015 till he retired at the age of 62, as I recall, some 10 years after he was terminated. And the reason why he made that time period applicable wasn't because it was in accordance with any facts or methodology. It was just because, as he said on the witness stand, that's what Mr. Patsfield's lawyers told me to do.
Okay, thank you, Mr. Van Fleet.
I appreciate the court's time.
Okay, the arguments are completed and the cases will be submitted. Thank you very much.
Thank you, Your Honors. Have a great day.
Thank you.
Bye-bye.